Adjournment request, if any, from item number 1 to 3.
Yes.
Maybe Lordship. With the consent of the other side, I beg to mention item 1, Lordship.
Yes.
My senior is out of station. Can it be on up to
2 weeks?
2 weeks, Lordship?
2 weeks. Yes.
Obliged, Lordship.
22nd August. From item number 4 to 9, adjournment request.
May it please the Lordship.
Yes.
Lordship, I'd like to mention item number 5, Lordship.
5.
Here, Lordship, we have to file our affidavit in reply, Lordship. That has been, we have sent it for waiting, but we have not received the approval yet. Lordship,
I have filed my reply. They have to file a rejoinder to them.
As prayed for on behalf of the appellant / applicant. Let this matter come up for consideration on 2 weeks,
2
1
weeks,
week?
Lordship. Yes, Lord, can you?
As early as possible. We can give you 1 week.
Well,
Our
my
tender is
difficulty is
empty.
I am traveling. I actually come from Delhi, my lords, and I am not in the country from 9th till 21st, my lords. My lords, I have it on 26th August, my lords.
That's, see, if you had just said difficulty of yours,
I'm sorry, my
I would
lords.
have agreed to it.
I agree.
If you start telling me the reason that
I
you're outside
apologize,
the
ma'am.
country, we may not accommodate.
I apologize, my lords.
Just tell me that you're in difficulty,
I
I'll accept it.
apologize.
It could be
I-
medical, it could be anything.
I apologize.
All right, not for sightseeing, no?
I'm no, my lords. There's some
2
personal
weeks,
difficulties.
2 weeks would help you?
Yes, my lords. My lords, I have it on 26th August, my lords.
26th of August.
Yes,
Deeply obliged, my
obliged,
lords.
Lordship.
And they'll supply it within a week or 10 days, my lords.
Yes,
Because
Lord.
there's been a pedantic delay at their end, my lords.
Definitely, we have not received the approval, Lordship. Definitely.
Obliged, my
Obliged,
lords.
Lordship.
Just a minute, Mr. Counsel, since you're from Delhi
Yes.
and you say what kind of delay? Pedantic delay.
My lords, there has been a yes, my lords. They have been,
What
their
do you-
approach has been
What do you
pedantic.
mean by pedantic?
Because their approach has been pedantic about the whole matter, my lords, because
Pedantic is different. Pedantic is panditipur. I mean, having great idea about oneself.
I
I don't think that fits in there.
my lords,
Okay, Lord.
also, my lords, it's a pleasure appearing before my lords because my lords, I had appeared in 2017 before your lordship and your lordship was sitting with Justice Ahmed. And my lords had passed an order with regard to the applicability in commercial courts and the appeal, if an intra-court appeal was applicable or not, my lords.
Can I have your name, please?
My lords, Mohit Paul, my lords. I was unsuccessful at that point of time before your lordships. Hopefully not this
That's
time.
right. Hope you don't mind my, correcting you with respect to you.
No, not at all, my lords. My lords, it's been a pleasure appearing
That,
before your lordships.
that is true for you also. You can always correct me.
My lords,
So
my lords are
whenever-
always correct, my lords.
All right. Yes.
Obliged.
Obliged, Lordship.
From item number 10 to 13, adjournment request.
May it please your Lordship.
Yes.
The concern which addressed, I beg to mention item number 10, Lordship.
10.
Yes, Lordship.
Yes.
So there's some difficulties, Lordship. Kindly pass over the letter for 1 week, Lordship.
As prayed for 1 week.
Obliged, Lordship.
There are 2 other things which I would like to tell you. This for the consumption of the bar. Passover means it's not for today. Adjournment means you can have an adjournment. Passover is that now it is going to be passed over. It shall not be taken up. So tomorrow. So this happens in the cases in the list which is running, So therefore, if you seek adjournment, all right. Passover means it shall come tomorrow.
I'm very sorry, Lordship.
You want an adjournment.
Yes.
All right. As prayed for 1 week.
Well, wait. Well, yes. Any other request?
May I please, your Lordship? Lordship, I beg to mention listing a case for hearing column, Lordship.
Yes.
On next week, Lordship. if possible.
Which is this matter?
Matter is that, Lordship, I filed a repetition, Lordship, challenging the plastic waste management rules, where the single-use plastic has been banned by the central government.
All right. You
Yeah.
challenge the rules of the state government.
In challenge the state government as well as central government, Lordship.
No. You must be sure. Which rule have you challenged?
Plastic waste management rules. Rule
Plastic
number
waste management rules of,
2016, rule number 42 of 42, Lordship.
all right. Has it been admitted for hearing?
Yes, admitted for hearing, pleading is complete, Lordship. They have filed also affidavit. We have also filed affidavit in reply.
All right. Give your slip in September 1st week.
Yes.
September 1st week.
Lordship.
Within
Fourth
first 5 cases or something. All right.
4th of September.
Obliged, Lordship.
May I please, your lordship?
Oh, this is August, no?
Oh,
Yes.
September. September last week. I'm so sorry. September last week.
May
Yes.
I please, your lordship?
Yes,
26th.
Mr.
My lord, I beg to mention for listing of an urgent to read appeal, my lord, regarding eviction, my lord. Lord, the learned single judge, my lord, has passed an, my lord, order.
When did you file the appeal?
retaping filed yesterday, my lord. It has already been serial number defect free, my lord, on Monday, my lord.
Monday, we don't know. Monday,
Because, my lord, on 7th of August, the demolition will be carried on, my lord. Then finally, my lord.
Monday, how's the list? Keep it on Tuesday. Tuesday.
My lord. Oblige.
Daily list for orders, item 2.
Condemnation. What is, no, this is regarding time proceeding. No, condemnation of delay with highway. Yes,
My lord, on 6/5/2025, my lord, the matter was taken up before the Lavazima court, where it was observed that the steps have not been taken upon 26, 27, 28, 29, and 33. Subsequently, my lord, we're taking the steps on 29/5.
that's all right. Now all the parties are here. Proceed with the argument.
My lord, today, my lord, the matter,
What do you want? Tell us.
my lord, what has happened is that in the state of Assam, my lord, a lot of stone crushing units,
Lot of?
my lord,
Yes,
have been procuring limestone
yes.
from unknown sources, my lord, which is another violation of the provisions of the Mines and Minerals Act of 1957.
Yes,
My lord, hence, and what has happened, my lord, the stone crushing units have been producing, have been producing, my lord, gravels and limestone gravel, which is of an inferior quality,
Hmm.
which has led to a complete downfall of the standards of my lord,
construction.
infrastructure in the state, my lord.
Hmm.
So that is the basic gist of the matter, my lord. If your lordship defers the matter by a day, I'll be glad to argue the matter, my lord.
Just a minute, we'll just do it. Now, what is your prayer in the writ?
Yes, my lord.
That you have flagged this aspect, we will take note of it.
Yes,
It's
my lord.
important.
Yes, my
What have you prayed for?
My lord, first we have implored, my lord, this honorable court for direction of mandamus to take immediate steps to prevent the use of limestone in stone crusher units. Because ideally, my lord, stone crushing units should not have limestone as one of the
That's
items.
true.
Yes,
So
my lord.
do you want the government
Yes, my lord.
to formulate any law with respect to preventing
fact, my lord-
limestones from being crushed and made gravel, which could be used in
In
construction?
fact, my lord, this matter
Yes.
is one,
Does it specifically form part of any one of the concession rules of minor mineral rules?
my lord, that's what I'm praying for, my lord. If your lordship defers the matter by a day, my lord, I'll be glad to argue the matter
All
in
right.
entire detail.
All right.
The steps
Yes,
have been
brother.
taken, my lord. The steps.
Please, all the respondents, I would request you to be ready in the matter.
Yes.
Come with your affidavit. We grant 2 weeks' time.
Absolutely.
File your affidavits. And then we shall see, because he has flagged a very important issue. He says that limestones ought not to be used in construction,
Yes, my lord.
correct?
Yes, my lord.
Because most of these crushers, instead of crushing stones, which would be a good aggregate for construction purposes, they procure limestone from somewhere, which is prohibited. And limestone gravel, it's very cheap. So these unscrupulous contractors, they use it in government buildings. That's wrong.
Yes, my
So what could be done? You suggest the ways. There are minor and mineral rules, concession rules,
Yes, my lord.
and all that, but that is not proving to be effective. Something has to be done by the government. Especially, I would like the intervention of the government also. Supporting the petition doesn't satisfy us. You support the petition. There is no difficulty whether you support or you don't support. We will be supporting the petition. You tell us what can be done to prevent limestone crushing. I mean, this is not an adversarial litigation. Take it from us. That also, even when these crushers have been made parties in this petition,
Yes, my lord.
right? Who appears for the stone crushers? So you will have to give an undertaking.
We are not doing it, madam. It is wrongfully.
So therefore, there should be no difficulty in giving an undertaking.
No.
If you're not doing it, we want to just ensure that you don't do it in future. Give an undertaking.
Explain everything.
Put in your affidavit. Tell us that this allegation is wrong,
Yes.
or otherwise we'll have you give an undertaking to us, which would be in very strict terms that you shall not do it. Otherwise, your license will be cancelled. should not do it. You should care for the state. You have other avenues. Anyway, take note. This public interest litigation has flagged the issue of a completely illegal and environmentally harmful practice of some of the stone crusher units operating under the Karimganj Forest Division in Assam of crushing limestones, making those into gravel, which are ultimately used in construction of government buildings. Stop. Limestone gravel is cheap and unsuitable for construction purposes. Even otherwise, the petitioner apprehends that in an effort to have cheap building material made, the stone crushers procure limestone through unknown sources and make it into gravel. Stop. Apart from this being illegal, it indirectly spirals a rise in the unlawful limestone mining in surrounding areas, which could lead to ecological apocalypse. Some of these stone crushers have been impeded as party respondents here in this petition, who are being represented by learned lawyers. The general refrain of the stone crushers is that the allegation is wrong and that they are only crushing stones and not limestone. This court has asked them to explore the possibility. This court has asked the learned advocates appearing for stone crushers to come up with an undertaking that they shall not crush limestones. The state in the Department of Forest shall also come up with definite proposal to stop this menace. Let this matter come up for consideration again on. They are giving you 3 weeks. Put in your affidavits, by which time the affidavits on behalf of the respondents must be filed, re-notified.
28-8. Item number 3.
This application is seeking condonation of delay of 245 days, madam. Madam, notice was issued, madam. And madam, there is no latest comment of the registry over the service, madam. May I pray that the matter will be placed before the registry, the Lawazima court? Because the last comment is of 10th of April, madam. The last comment is of 10th of April, after notice was issued on February, madam.
Notice is returned answer with the postal insufficient. No, you'll have to find. It's a review. What is correspondence? Response number 12789. Oh, all are government respondents.
Madam,
Government officers.
I can even serve the standing council.
Who appears for the state?
The CGI's name is reflected.
Who appears for the state? Please.
No. Mr. Bora, that is not.
Who appears for the government of Assam? Some lawyer, any lawyer, not in this case, but any lawyer appearing for government.
Standing council revenue.
Please step forward. Look, all the respondents are government officers. You accept notice on their behalf. And Union of India inform the Central Government Council.
मतलब 4 to
We are adjourning it for tomorrow. You please ask the lawyers,
I'll-
respective lawyers to be here.
Lodge.
They will accept notice.
Lordship.
We can't keep this matter pending. Huh? So
Lordship.
we are only adjourning it for the day.
Lordship.
What is your name?
I'm Dina.
Your?
I'm Dina.
Mr. Nath, please inform the lawyers. They'll be here, they'll be accepting notice. And in case they would like to respond to the petition, contest the petition, all right, they can do it. We'll grant them time, all right?
Lordship.
Pass over, just pass over. That means it comes on Monday. Oh, you have to write, no? Let this matter come up for consideration on. Sorry.
Item 4.
SLP.
But it has been agreed, but it's been contested.
SLP order has been passed. Stay.
I had a problem. Yes.
Let's see. Dear.
On 28/7/2025, the second paragraph, particularly Manish Purva, please write it.
In view of the order passed in. SLP number. SLP civil. Bracket close diary number 29691 of 2025. The matter is adjourned to. We give 8 weeks.
So in fact, my submission is there is no curriculum.
There is no
There is
louder.
no curriculum deliberate by should one about the doctor as on today. And,
No.
let's
Let it remain. Stay. Willful violation or not, suppose your SLP is dismissed. Then it revives, no?
Lordship, the petition has been filed much later, Lordship, after the,
Doesn't matter. If there is a stay by the Supreme Court, nothing can be done. You are a civil servant, aspirant.
Lordship.
You have not passed your prelims examination.
Lordship, as per the first answer key.
That's right. So ultimately, your name did not appear in success. You passed the mains, but not the prelims.
Lordship. As for
First
the
time you
second-
passed, but there were changes. All right, we'll see.
No.
In view of so and so, the matter is adjourned to 8 weeks.
15 October. Item 6 and 7.
These matters are being settled, my lord. Some time is required, my lord. 1 4 weeks time, my lord. Out of 4, my lord. They are settling them.
Parties are, my lord, reached to an agreement out at the fourth month. But I think the work, we have a small IoT and the contractor hearing. There is no 4 weeks time, so my lord, to formalize everything, probably.
No, the order dated 20th of February 2024.
Yes.
You were supposed to make, the IIT was supposed to make a payment of rupees 8 crores.
Yeah.
Is that correct? You represent the IIT.
My lord.
So make that payment.
My lord,
Are they ready with the solvent security?
my lord,
Yes, we have filed it.
some-
You're fine.
Sure.
They have submitted. IIT had certain objects.
Tell us when will you pay?
My lord, they are now settling the entire matter.
The
Entire,
lawyer will tell us, no?
my lord,
Has it been settled?
No. Yes, my lord.
they are.
Yes, settling the matter, my lord.
Settling the matter.
Yeah.
Out of state court.
Just 4 weeks time to they will.
Ujjwala is there, my lord.
The learned advocates for the parties jointly seek an adjournment in order to facilitate negotiations between them for an out-of-court settlement. Stop, re-notify 4 weeks.
8, 9. Item number 8.
My lord, the application.
49 days, notice,
Lodge.
both modes returnable on so and so date.
Indeed.
Item number 9.
Wait, please, Lordship.
Same order, notice on steps taken, 2 weeks. Returnable 6th week.
For respondent number 1, he is there, Lordship.
Number 1.
Then no need of notice to you, no? Thank you, sir. So you accept notice on all, on behalf of all 1, 2, and 3?
Only one.
Why?
I was the petitioner. 8, 9. It's okay. 8 or 9.
Why?
Would be,
It's not that who filed this petition? Union of India. But the Union of India is the appellant.
I do not think 2 and 3 is necessary.
Principal registrar. No, 2 and 3 is not necessary. Only 1 is necessary. Look here. Notice to respond number 1 is accepted by Sri
they are talking about.
so and so letter advocate. Stop. Let the response to this petition be filed positively by the next date. Be notified 3 weeks.
In the memo, the prayer post. At page 20. But they have not made any prayer regarding first day or regarding.
File it. No, file your response.
29-8.
Of like,
Item 11.
Meet Mrs. Lordship.
1 second. 1 second. Yes,
My lord, by this.
you hold a degree in electronics,
Yes, my lord.
right?
Yes, my
The post was advertised for physics.
physics,
The respondent here,
my lord,
the writ petitioner, he
Right.
had physics.
my lord.
So
My lord,
what ground do you have?
electronics is equivalent to physics.
But if it is,
Yes,
if a subject which is more in alignment with the required, qualification, where was the question of diverting? Where was the question of straying
my lord,
in other field?
in all the other states, advertisement was issued whereby, my lord, for the post of, my lord, subject is postgraduate teacher in physics. All the, my lord, electronics and physics and other subjects, my lord, they were incorporated.
That is the
Only in
argument which you raised there, no?
Yes, yes, my lord. But only thing, my lord, I like to point out before lordship. Page 169. Paragraph 6 of the
169,
judgment,
yes.
my lord. Paragraph 6 of the judgment, my lord.
Paragraph 6 of the judgment.
My lord.
Read.
My lord. It may be mentioned that by order dated 28/4/2023, this court had directed the Lawrence Standing Council for the Secondary Education Department to obtain specific instruction as to whether the Directorate of Secondary Education Assam permits MSc degree holder in any discipline to be appointed as postgraduate teacher in any science related subject, taking note of the fact that the respondent 5 is a MSc in electronic science and has been selected for appointment as postgraduate teacher in physics, which would have a vice versa effect that any postgraduate holder in arts, science, and commerce stream to be eligible for being appointed as lecturer for the post of postgraduate teacher in any discipline covered by the Department of Arts, Science, and Commerce. On such query, the Director of Secondary Education Assam had written to the Academic Register Guwahati University regarding the clarification on MSc degree in electronics, and the reply of the Academic Register was still
It would
awaited.
be unfair. It would be unfair. You must be the only person with electronic science having applied. If this were the intention, perhaps others also would have done.
My lord, I have the BSc degree with major in physics. Major in physics, and the electronics is a part of physics department, my lord.
I don't think you have a case, sir.
My lord, moreover, my lord, the writ petitioner, he is working in a different school. Only for the academic purpose, this writ petition was filed. He was working in a different school, my lord, and for the impugn order, my lord, I have lost my job and I have become overseas. That aspect also be kindly considered.
What can be done, no? What can be done? Tell me, what
My lord, the
relief do
department
you
has no
want?
objection.
Huh?
The department has no objection in appointing me as my postgraduate teacher.
But we
The
are not
school has no
preventing
objection.
We are not preventing the department from appointing you, are we?
Yes, my appointment has been set aside, my lord.
Your appointment has been set aside for the post for which advertisement was issued.
My lord, the department that they had, by knowing me to be the postgraduate degree holder in electronics, I was appointed as my lord, subject teacher. in
That decision
physics.
was under challenge, no?
But that decision.
That decision has been challenged. The single judge says, and rightly so, we agree wholly with him.
My lord, the department says that my lord,
That the respondent was a better choice, no?
my lord, my submission is that my lord, lordship, my lord, the learned single judge should have waited for the my lord, clarification from the department, my lord, department. That was not done, my lord. The department
not
did
a
not clarify in this aspect.
Sorry, it's difficult. I mean, the government should not have allowed you. The department should not have allowed you in the first instance.
In
Your
the-
application should have been rejected because you don't have the requisite minimum qualification of MSc in
Yes,
physics.
that is the
That
only,
stream is important.
my lord, but
You may be, the electronic science may be an allied subject of physics, would be coming under physics, but that is not the required. Take the.
lordship may kindly peruse page 116. 116, there is an advertisement, my lord, issued by the Haryana Staff Selection Commission. Category number 12, 687 post of postgraduate teacher physics, MSc physics, applied physics, nuclear physics, electronics, science.
That's because of the advertisement.
Yes.
This advertisement does not control this as a recruitment process.
If my lord, the present advertisement also does not exclude the persons my lord, having.
Suppose IIT takes out an advertisement that for each subject, for general subject, for specialized subjects, these persons would appear. Can you import that advertisement, that condition here? This was for us.
My lord,
This
the
was for a
post is-
teacher in a school
The post
for
is,
the discipline of physics.
post is my lord, postgraduate teacher in physics. Post is postgraduate teacher in physics. In the other, all the other states, my lord, they are taking this kind of stand. That is 116. Lordship kindly turn to page 130. This is an advertisement, my lord, issued by Atomic Energy Education Society.
Yes, we have heard Sri IIT Psychiatry.
My lord,
Am I right?
my lord.
IIT Psychiatry Council for the appellant and S. Kanungo for the respondent. The appellant is aggrieved by the judgment dated so-and-so passed by a learning single judge in WPC number so-and-so, whereby the prayer made by the respondent / writ petitioner therein was allowed, comma, the appointment of the appellant on the post of postgraduate teacher in physics at Dimau Higher Secondary School, Dimau, was set aside and a direction was issued for appointment of the respondent / writ petitioner on that post. It appears from the records that against an advertisement for filling up the post of postgraduate teacher in physics at the school in question, comma, the appellant and the respondent had applied. But there is, but the appellant was selected, even though his qualification was MSc in electronics, which was not the essential subject advertised, which was not the discipline advertised for the post of PGT teacher in physics. The learned counsel for the appellant contends that a master's degree in electronics is only an allied subject and would come under the bigger umbrella of masters in physics. Stuff. He has also shown exemplars from other recruitment processes whereby the subjects of whereby subjects like physics, advanced physics, electronics have been taken to be allied subjects. And there is generally no proscription in persons having degree in allied subjects from applying for the post. The learned single judge, however, while allowing the writ petition preferred by the respondent, rightly found out that the basic requirement under the advertisement was postgraduate degree in physics and not in electronics. And there was nothing on record to indicate that the state government had held that physics and electronics would form part of the same discipline, only same discipline, and electronics would be an allied subject of the physics or of allied subject of the subject physics. So, considering this aspect of the matter, with which we are fully in agreement, the appointment of the appellant was set aside and the respondent was directed to be appointed in her place. It is really, in her place. We do not find any perversity in the judgment or perversity in the judgment for us to interfere. The appeal has no merits.
May I make a submission, madam? As the petitioner also not joining the post, the school is to read whether the post, my lord. If the post is advertised, my lord, that aspect may be clarified. by the
We would be crossing our line. That is not,
He
you
is
have
not
challenged
running.
the order.
Or working in here in different.
You make a
my lord.
prayer, you go before the school. If they don't come before the single judge, ask for it. In appeal, we can't do that, no? We have a limited remit.
Yes, my lord.
We generally set aside orders which are beyond remit. We will not be passing any order beyond our remit, no? Well, yes.
Item 12.
226 is something different.
Yes, ma'am.
Yes.
May it please your lordship.
Yes.
Now, in the writ appeal, we are basically challenging an observation made by honorable single judge at paragraph 14 and page 14F.
Paragraph 14.
At page 14F. If I may briefly indicate what led to this
Let us
situation.
first see the paragraph that offends you, and then we'll see.
My lord. Of the writ appeal, paragraph 14 at page 14F. May I read? The respondent number 10 is accordingly directed to register a case against the petitioner's school apparently run by an unauthorized person, that is she, Angles Baxla, as there appears to be prima facie case of cheating in unauthorizedly running the Ekalavya Model Residential School, Dolbari, and taking fees from children by giving the impression that he has been given the authority to run the said school.
No.
My
This is not an off the cuff remark.
Correct.
This is not an off the cuff
It
remark.
follows an inquiry. It follows an inquiry. So if my lord permits me, may I just?
And what kind of inquiry? Suppose prima facie it is found that there is some cheating, some bungling.
Correct.
The starting point of any such inquiry would be a police inquiry.
Absolutely.
And therefore FIR.
Absolutely, my lord.
We can only say that it shall not be inquiring, the police under the investigation shall be fair and shall not shall not take it as a finding that you have really committed the error.
Presently,
Beyond this, we cannot do it.
my lord, presently, the honorable single judge in the criminal original jurisdiction has granted that pre-arrest bail also on this matter. What I would like to apprise my lords, my lord, what error went through, because it might have a bearing tomorrow.
You can rest it out there.
Very well.
You
That
can rest,
liberty, that liberty.
you can rest it out there. Take it up. Unless you write it to me, I will not. Yes, Banik. You are Mr. S. Banik.
Lordship.
We are trying to remember the names of the adult. Heard Mr. S. Banik, learned. Your senior, learned advocate for the appellant. And who appears for the respondent? And Mr. K. Kalitha. I am so all the responses. And so for the respondents. By the impugned judgment dated by the impugned order dated 23/6/2025, a learned single judge of this court directed respondent number 10 / the special DGP CID Assam, Ulubari, Guwahati, to register a case against the school, namely a Club Model Residential School in the district of Baksa, which perhaps was being run by an unauthorized person, namely Sri Angelus Baksla. The Land Council appearing for the appellant apprehends that with such observation that there is that it constitutes a case of cheating, the police, after registering the FIR, would take it as an open and shut case and would hold Sri Angelus Baksla and the school to be guilty, which would not be a fair investigation. Stop. In our estimation, such an apprehension is unfounded. Stop. In fact, only in order to verify whether the school was being run by an unauthorized person, FIR has been directed to be registered. Before giving such direction, the learned single judge was careful in asking for a report from the Special Superintendent of Police, bracket, Crime Against Women and Children, bracket close, CID Assam, and the letters issued by NESTS, which was also circulated to the lawyer for the appellant.
On the same date, the order was passed.
To the lawyer for the appellant. We do not intend to interfere in this appeal. We do not think it to be necessary to interfere with such a direction passed by a learned single judge in this appeal. But we close this appeal with the liberty to the appellant to approach the learned single judge, who is still in the scene of the case, to clarify that any observation made in the order passed by the learned single judge would not come in the way of the police fairly investigating the matter. The appeal stands disposed of, but nothing more can be done.
I'm grateful.
Item 13.
Yes,
My lord, matter pertains to family pension, my. I'm the legitimate wife, my lord.
you are the legitimate wife,
Yes, my first wife, legitimate.
first wife.
Yes, and the second marriage was contracted during the first marriage, my lord. My late husband didn't divorce me, my lord. But he had contracted the second marriage with the respondent.
That's right.
Mother.
So you would get the pension,
Yes, my lord.
and the offspring from the second wife also would get the pension. So there is no difficulty. Correct? So I don't think you have any other case. You just have to part with half the money that you expect from the government. You're the stepmother, no?
No. Oh, yes, my lord.
You're the
Stepmother of
stepmother.
respondent eight.
Don't be so close-fisted. She is also unmarried. She is pursuing her studies.
No, my lord, unmarried.
Still unmarried, I said.
Yes.
Therefore, if had she been married, situation would have been different.
Yes.
But they can answer. 143 of the pension rules.
Yeah.
The rule I have read there. In the,
You are appearing for the daughter.
the rule, amended rule is at page 54.
Is the same compilation.
No,
in the
Memo of appeal,
Page 64.
page 54.
Come to the relevant part.
B, in covering all the clause C, the conclusion marked at a certain step, provided the participant shall be allowed to continue beyond 21 years of age to an unmarried dependent daughter of a government servant, subject to the fulfillment of the following condition. These are the conditions, number 2, that certificate of non-marriage and non-consented. These are the conditions, and I have annexed the conditions in page 29 and page 69. 68 and 69. That I have annexed there, and there was an affidavit by the government before the last single judge admitting to the fact that
All right, we are dismissing as a field. Don't worry. We have heard Shri
PR Sharma.
P.R. Sharma for the appellant and Mr.
P.K. Roy
P.K. Roy Chaudhary for the respondent. The learned single judge, why it is judgment dated so-and-so passed in WPC number so-and-so, has directed that both the appellant and the respondent would receive pension, would receive family pension in view of the amendment made in section 143 of the Assam pension rules. The daughter born out of the wedlock of the second wife of the deceased government employee approached the court seeking family pension, which was allowed. The facts necessary for disposal of this appeal are that the deceased government employee was married to the appellant with whom a son was born who is now a mason. The daughter born out of the second wife of the deceased employee is still unmarried and prosecuting her studies. The learned single judge, after going through the pleadings and the submissions made on behalf of the parties, found that the dispute between the widow and the unmarried daughter of the late government employee could be resolved by directing for dividing the family pension into two halves, that is in equal proportion. This was only in keeping with the requirement under the Assam Service Bracket Pension Rules 1969. It was therefore directed by the learned single judge that the respondents ought to process the claim of the wife and the daughter of the deceased employee in the light of the amended provisions of Rule 143 of the Assam Service Pension Rules, and forward the pension papers to the Office of the Accountant General, Assam, as expeditiously as possible, but not later than 60 days from the date of the receipt of the certified copy of the order passed by the learned single judge. Along with the proposal, it was also directed that it should be indicated in the proposal along with the proposal, comma. Another proposal of the proportional disbursement of arrears of family pension was also required to be sent. There is nothing in this order which requires any, there is nothing in this judgment which requires any interference. All that we can observe is that the respondents ought not to delay in computing the family pension and making it available on a regular basis to both the appellant and the respondent. The appeal stands disposed.
Deeply obliged, my lords.
Supplementary list for hearing item 22.
Yes, you conclude your arguments, then we'll ask Mr. Bora to start with another appeal. कल ही जो सुन रहे थे वही रहे.
Lordship, I'll reiterate my submission, whatever I had made it yesterday, that the victim's mother identified the accused, Bikash, my lord. Then the second circumstances are peer persons identified could relate.
Yes.
Lordship. Second circumstances are peer persons identified the accused persons from his appearance, which they have noticed in the CCTV footage, and along with the way he used to walk, your lordship. And from his appearance, they could, lordship, they could see that the same thing, he is the same and the one person, my lord. Then, your lordship, third circumstance is the earring, which belonged to one of the victim, which were found in the bag, which was carried by the accused person, lordship, in the platform, my lord, while he was crossing the platform in Tinchukia, my lord. Then, there's a lordship which I could find, there's DNA profiling, which could match, my lord. DNA profiling as well as serological report I'll be referring to. Vis-a-vis the judicial confession, it was in accordance with law, it was recorded by a magistrate. The confession was given in front of the magistrate by stipulating for all the formalities and as per the rules, lordship ascribed by the Honorable Guwahati High Court, my lord, in proper form. Then the motive of rape and, your lordship, the other one, the murder, your lordship, your lordship understands the motive from the gathered from his action, my lord. His motive was to rape and then thereafter the murder. Lordship, then lordship, you collected specimens, lordship, in presence of the witnesses, which was not challenged by them, your lordship, by the accused person in the cross-examination. These are the circumstances. Lordship, yesterday, lordship, I made a submission as regards the recovery of the earrings, which were identified by the victims, one of the victims' sons, my lord. Because it was sent immediately through WhatsApp to them, and they could see that it belonged to their mother. Yes. Lordship, if your lordship discussed this part, then the DNA profiling, which I'll be referring to, as well as the serological report. First, I'll take your lordship to PW 39, my lord. It's at page 71, volume 1. Lordship, can we have a look, my lord?
Please, read.
PW 39, may I read your lordship? Is a scientific officer, Serology Division, Directorate of Forensic Science. On 19/7/18, I was working as scientific officer at Serology Division, Directorate of Forensic Science, Assam, Kailipura, Guwahati 19. On the day, by memo number so-and-so dated 18/7/18, advising the examination of 2 parcels per messenger was received in his office in connection with Simoluguri PS case number so-and-so under 302-376 IPC. Mode of which parcel found to be packed and received, and a description of the seal. The parcel sealed ice box and 1 sealed big size paper envelope consisted of 15 exhibits enclosed with a cover, which was sealed with impression of a seal corresponding with the seal impression forwarded seal. Then 1 One brown colored underwear contains stain of suspected blood and semen marked as exhibit A, MR number 07/2018. That is 04042A. Lordship, then 04042A, my lord, matched with Lordship, then I'll be referring serial number 4. One black colored jeans long pant contains stain of suspected blood of semen marked as exhibit D, 04042D. And one red and white colored gamusa contains stain of suspected blood and semen marked as exhibit E. Lordship, report result of examination, exhibit 04042A, your lordship. And exhibit 04042D and 4042E and 04042F, my lord. It gave positive test for human blood and semen. Lordship will find this at page 72. Then there is DNA profiling, my lord. Lordship, may kindly have a look at the evidence of PW40, my lord.
No, you just read out the evidence of the serologist.
Yes,
With respect to what?
that the apparel of victim matched with the apparel of this one, my lord, this accused person.
No.
My lord.
Victim's cloth was profiled.
My lord,
Are you sure?
one black color so-and-so contains, lordship, may I first take your lordship to the
No,
DNA
you
profile?
have read out, you please tell us what is the comparison, what is the profiling? I mean,
Zero
DNA
four
profiling is
zero
not
four-
for confirming that he is Mr. So-and-so, he is Mr. Das. The
Lordship.
profiling is for comparing
My lord,
the swab which is collected from the lady
my lord,
with the profile of this man.
my lord.
And where is that?
Lordship, it's there in the DNA profiling, my lord. DNA profiling,
Profiling for matching what?
matching that the specimen which is
Where is
collected.
the evidence that the clothes of the victim were taken, sent, seized?
Yes, it is there from the evidence of PW43,
What does it say?
lordship.
Orders, item 1.
Meet with the lordship. Lordship, in this case, I am paying for little accommodation, my lord. This case is supposed to be done by my lord Justice R. Mazumdar, my lord.
By?
R. Mazumdar, my lord. Justice.
It was, I mean, now he is
My
there.
lord. Therefore, my lord, I need some time to, my lord, department needs some
But
time.
then why can't we do one thing?
My lord.
You find an IE also.
My lord, for delay. my lord.
Condemnation.
Condemnation delay.
You are for the state of Assam.
My lord,
So we issue notice
my lord,
to the respondent.
my lord.
That way we decide. Otherwise, normally, if the parties would have agreed, we would have decided this review.
My lord.
I don't think there is anything else. No. Prima facie, that does not appear to be a case of review. Huh? Well, let notice be issued to respond number 1 on steps being taken by the petitioner / state of Assam for issuance of notice, both modes returnable on. It give a date of 4 weeks.
My lord.
4 weeks.
Obliged.
And be ready on that day.
My lord.
We would decide the review also.
My lord.